morning, and thank you for joining us. My name is Kelly LeGrand-Wiener, and I'm the managing attorney at Scott Legal. If you're here today, you likely have an E-2 visa or you're considering an E-2, and you are in good company. This firm was founded on an E-2 visa 8 years ago. The firm has a focus on investor visas and has processed hundreds of E-2 visas. We've also helped some of our clients move from an E-2 visa to a green card, and this brings us to what we plan to speak about today. During this webinar, we're going to spend some time speaking about various green card options that are available to individuals on an E-2 visa. A few things before we get started. We will continue with this webinar series, doing at least 2 webinars a month on different topics. We have webinars scheduled regularly, and we regularly add new webinars. Also, at the end of this webinar, we'll send out a few things. This PowerPoint that you'll see today, a link to where you can sign up for additional webinars. And also this webinar will be recorded, so you will get a link to the recording. Today, I will be speaking on the options for E-2 visa to green card. And as well, if you have any questions as the presentation proceeds, feel free to type them in the Q&A or in the chat box. And if we have time, we will get to them. So to kick everything off, we will get started with discussing some green card options. All right, so how does the green card system work? Green cards are available in multiple categories, including family, employment, and investment, among others. Here you have a listing of kind of family-based green cards, which are broken down into 2 categories: immediate relatives and preference categories, and we'll discuss that more in the next slide. Additionally, you have the listing of employment-based green cards. So there's the EB1 for individuals of extraordinary ability, EB2 green card through employment, and this encompasses both a national interest waiver, which we'll talk more about and can be kind of a self-petition, or the PERM process, which is where you have a company sponsor you for a green card. The EB3 is also available to individuals where a company wants to sponsor them for a green card. The EB4 is for religious-based workers, and the EB5 refers to green cards through investment and creation of US jobs. So let's look at family-based green cards. In this first category of immediate relatives, that encompasses spouses, unmarried children under 21, and parents of US citizens who are over 21. So immediate relative green cards refers to this narrow list of relatives of US citizens. And for immediate relatives, there are certain benefits. For example, a visa is always available in these categories. So you always are able to file kind of your I-130 immigrant petition along with, if the person is in the United States, a green card petition, an I-485 with US Citizenship and Immigration Services, or if you are filing, if your relative is outside the United States, you file the I-130, and upon approval, it would immediately be sent to the National Visa Center for processing, because a visa will always be available. Let's talk about preference-based categories. So there are other family members who can be sponsored in preference categories. And in the preference categories, this encompasses people that can be sponsored either by legal permanent residents and US citizens. So in this first category, immediate relatives, it's just for US citizens. But in the preference category, it includes unmarried children of US citizens who are over 21, spouses and children unmarried and under 21 of legal permanent residents, unmarried children of legal permanent residents who are over 21, married children of US citizens, and siblings of US citizens, as long as the US citizen is at least 21. So, in these preference categories, you may have some backlogs. It's important to check the visa bulletin, which is updated each month, to determine whether a visa is available in your category. If a visa is not available, your family member can still file the immigrant petition, but then you could not file for the green card until your preference category, your priority date becomes current. Once a visa is available to you, the process, either through consular processing or adjustment of status. Consular processing refers to the process where you're outside the United States and your relative will go to a US consulate to get their immigrant visa issued. Adjustment of status refers to the process where you are inside the United States And then you can file the I-130 and perhaps the I-1485 even concurrently. Once the I-485, the green card petition in the US is filed, you can also file for work and travel authorization. It is important to note that not every status permits you to change status. So you want to speak with an immigration attorney to see, for example, if you're here on ESTA, generally that does not permit you to adjust status, although there are exceptions for immediate relatives. So let's move to the employment-based green card categories. The first one we'll talk about is the EB-1A. So this is a green card that's available for people who have extraordinary ability, who have one of the few who've reached the very top of their field and achieved sustained national or international acclaim. So in order to qualify for this category, you either have to have one extremely prestigious award, a Nobel Prize, something like that, or you need, more commonly, you'll show that you meet at least 3 of the criteria that are listed on the PowerPoint. So, evidence of membership in associations, published material, evidence you've been asked to judge the work of others, your original contributions, scholarly articles, your work being displayed in artistic exhibitions, a leading or critical role in distinguished organizations, evidence you command a high salary, or commercial success in the performing arts. It is good to note that, this past year, the current administration has made, kind of some policy changes to try to make this category more friendly and more open. So for example, they added clarification that for published material about a person, in professional or major trade publications or major media, this doesn't actually have to be a printed article. You can submit other forms of evidence, such as transcriptive audio or video coverage. So they kind of expanded that to allow people to include that additional evidence. Additionally, for the extraordinary ability classification, a person may satisfy a leading or critical role criterion through a qualifying role for a distinguished department or division, in addition to an entire organization or establishment. So with some of these policy changes, the administration is indicating, a focus on trying to make the criteria more friendly, easier to meet, really allowing the officers to find that you meet this criteria without just a very narrow reading of each of these, each of these requirements. Also important for this category is to know that it's not enough to just meet the plain letter of the criterion. So let's say, you evidence of, authorship or scholarly articles in professional or major trade publications or major media. So the fact that you have met that criteria, you've authored an article on its own, maybe that means you meet the first step, but then there'll be a second step where they look and see, okay, does this mean that this is someone who's really achieved sustained national or international acclaim? So it's not just, do you meet the plain language? Have you been, asked to judge the work of others? But what type of judging competition was this? Was it very prestigious? Did you have to pay to become a judge, or did they select you because of your expertise in the industry? So all of those things are very important for step 2 to show that, not only do you meet the plain language, but actually that your work is elevated enough that you could really be considered someone who's risen to the very top of your field and achieved this sustained national or international acclaim. One big benefit of the EB-1A category is that you do have the ability to self-petition. So you do not have to wait for an employer to sponsor you. You actually can, on your own initiative, file this petition with all the information about you and a statement explaining what you plan to do in the US, which may be to work for various organizations, to work for yourself. On that note of working for yourself, the EB-1A can be used by entrepreneurs, and we'll talk more about entrepreneurs later in the presentation, but the EB-1A can be a good option because you can self-petition. If you have your own company, and you plan to run it in your area of extraordinary ability, that can go into your personal statement to explain, part of what you plan to do in the United States. If you run a very successful company, that can be used to bolster, your eligibility for this type of visa. When you apply for the green card, it's a two-step process. So the forms that you'll file are, if you're in the United States, the I-140 and the I-485. So the I-140 is the actual immigrant petition where you'll provide the evidence that you meet all of these criteria for extraordinary ability. The I-485 is the green card petition that we talked about this in the earlier slide with family-based petition. So it's the same form and just under this different employment-based category. If you're outside the United States or you just don't want to file the I-485, perhaps you need to travel frequently and you can't wait for travel authorization to come through. You can also apply through consular processing. And then once the I-140 is approved, your case would be sent to the National Visa Center. Once they confirm they have everything they need, your case is sent to the consulate, and then you attend an appointment at the consulate to get your immigrant visa. So let's look at the national interest waiver. So this is a category that's become much more friendly to entrepreneurs in recent years. There was a case a few years back called Matter of Danazar that specifically laid out that this NIW, national interest waiver, should be much more friendly to entrepreneurs. There is a threshold criteria you need to meet of either an advanced degree or the equivalent, meaning a bachelor's plus 5 years of progressive post-baccalaureate experience, or you could qualify under exceptional ability if you don't have a degree. Exceptional ability is somewhat similar to the standard for extraordinary ability, a bit lesser, but you need to show that you meet at least 3 criteria to qualify. So it's certainly, I'd say, much more straightforward for the NIW. If you do have that advanced degree, it's a much more objective standard to meet. Versus exceptional ability, you're going to need to do, I think significantly more on the evidence side to show that you meet that criteria. There are, 3 things that you need to prove for a national interest waiver. So first is that you have an endeavor that has substantial merit and national importance. This can be appropriate for a wide variety of areas. Business, culture, health, education, technology, science, and being an entrepreneur. Endeavors that further human knowledge in key areas such as medical advances or military or civil technology. Anything that produces a strong economic impact. This could all have, kind of substantial merit and national importance. When we're looking at national importance, the government is going to consider the potential future impact and its importance to the United States. One of the things in Danazar that was really helpful is they talked about how a local or regional proposed endeavor could still be of national importance. For example, the creation of jobs in an area that, has poor, hiring figures or, kind of poor employment figures. You can look at the economic benefit and impact to a community in a more local or regional space. So it can now be based on this one location as opposed to having to show nationwide. Even if something is not impacting nationwide, it can still have national importance. So that was a very important distinction. The second requirement is to show that you are well positioned to advance the endeavor. So this section will focus on the applicant's background and accomplishments. In order to grant the green card, the government has to feel comfortable you'll actually be able to accomplish the job that you propose. So having a track record of success in your field will greatly strengthen this part of the application. They will look at, you don't have to prove it's already successful. You just need to prove that, more likely than not, it will be ultimately successful, but they will, look into your record and see, do you have a track record of success? To prove that you can advance this proposed endeavor of yours. So if you're starting a new company, but you have a track record of successfully starting other companies in the past, perhaps that you sold or that merged, that's always very helpful, for your case. The last requirement is, on balance, it's beneficial to the US to waive the requirements of the job offer and labor certification. So things to consider here are whether it's impractical for the applicant to secure a job offer or for the petitioner to get a labor certification in light of the nature of the endeavor and the applicant's qualifications. So for example, for entrepreneurs, the labor certification system is not set up to allow any majority owners to qualify. If you are a majority owner of a company, you're not going to be able to have your company sponsor you for a green card through the perm because there just won't be, it won't pass the test of showing that there was really a bona fide job opportunity open to US workers because you own the company. So that can actually be a helpful argument for why you qualify for the national interest waiver. You can also argue that even if there are other qualified workers doing this work, the US will benefit from your contributions because they're so important. So if you're doing important research in medicine, science, technology, if you are working on a company that has, kind of maybe revolutionizing the way that kind of software processes are happening. Anything that you can reasonably argue, yes, other people are working on this, but, the work I'm doing is important enough that it's not going to be a problem for the US labor market to also, have you working on it. You can also argue that the national interests being served by your contributions are sufficiently urgent to waive the labor certification. So for example, if you work in national security, if you work in an area that you can argue is increasing US competitiveness in a particular field, for example, military aerospace research, these types of things are all very helpful to show that you meet this third prong. And similar to what we discussed in the previous slide, if you're doing an EB-2 national interest waiver, you would go ahead and file the I-140. The I-140 is going to have all of the documentation about, how you meet the threshold considerations and the three prongs that we just discussed. And then you would file the I-485 or go through consular processing, when you're ready for that step. So let's talk about the EB-2 in the context of perm and also the EB-3. I think this, so this refers to a company, a U.S. company sponsoring someone for a green card. So in this case, for example, we've had clients, perhaps they're here on an E-2 and their spouse is also on an E-2 and is working for a company, and the company wants to sponsor their spouse for a green card. So that is one way that sometimes E-2 visa holders will move to green card, is that they're actually working at their company, their spouse is working at a US company, and the US company decides to sponsor their spouse, and then they are derivative on that application. Similarly, sometimes we've had clients where with their E-2, they have multiple business to business relationships, and one of those US companies makes them a job offer for the future, and they are then able to go through this EB-2 or EB-3 perm process to be sponsored for a green card. So the EB-2, as discussed in the previous slide, does have some threshold requirements to qualify. You do need to have that advanced degree or equivalent or exceptional ability. For an EB-3, generally you'll have a bachelor's degree if you're qualifying under the professionals category. Companies can also sponsor people in the EB-3 category who are skilled workers, so 2 years or more of training, education, or experience, or what they call unskilled workers, so where a job requires less than that 2 years. There's a 3-step process for applying for a green card through the perm. So the first part of that is the perm process itself, and this is also I'd say the longest part of the process. So as a first step, the company and the attorney need to kind of look at the job description and ensure it's perm compliant, or perhaps make some updates for it to be perm compliant. And what that means is that when you are drafting the job description, it has to, the government wants the job to be as open as possible to US workers, so you can only include requirements that are the minimum requirements to do the job in a reasonable manner. Once that's all set, then you would file for your prevailing wage. That's where the company is going to ask the government, what do I need to pay for this position? The company will make a recommendation, but the Department of Labor has the ultimate say over what the prevailing wage will be. Once the prevailing wage has been returned, it will say, yes, when the person gets the green card, this is the wage that has to be paid at least. If the company agrees to that, then you can start with the recruitment process. Recruitment is done by the US company, where they actually do have to post for the job in various places, such as the state workforce agency, newspaper advertisements, and things of that nature. They have to review the resumes that come in. They have to interview people who appear to be qualified. And at the end, they have to prepare a recruitment report that explains exactly what steps they took and that they really conducted recruitment in good faith to test the US labor market to determine if there were any willing, qualified, and available US workers for this particular position. If there were not, if recruitment did not yield any willing, qualified, or available US workers, then they can go ahead and file the labor certification. Once it's filed, it may be certified, and that lets you move on with the process. It can also be audited. So as listed here, there are some specific audit triggers. For example, if the job requires a foreign language. Really, there are very, very high standards and difficult to meet standards for when a foreign language can be listed on a perm. There are some places where it's obvious. For example, if you're petitioning for somebody who's a Spanish language teacher, obviously there needs to be a foreign language requirement. However, in the majority of cases, it can be very difficult to meet this foreign language, to meet the criteria they put in place for the employer to put in a foreign language requirement. Additionally, if there are any requirements outside of those normally required for the occupation, that can also be an audit trigger, for the perm. This perm is not filed with U.S. Citizenship and Immigration Services. It's actually filed with the Department of Labor. And as I mentioned, it can be certified, it can be audited, or it could also be denied if there is something, in the form that just wasn't filled out correctly, or some issue there. If the case is audited, often the Department of Labor will ask to see all of the proof, of the recruitment that was conducted, and they will review it. The company is also required to keep all of the audit documents for at least 5 years after submitting the application. Once the perm is certified, then you can move on to the I-140 and the I-485. For the I-140, at that stage, the company is going to be showing that they meet their requirement of ability to pay the prevailing wage. So, financial documents or things of that nature to show that they have that ability to pay the prevailing wage. And then you'll also have to provide proof about the foreign national's background. So if the job required a bachelor's degree plus 1 year of experience, in the I-140, the applicant will have to show they have that bachelor's degree and that 1 year of experience, and that they had it before they joined, the company that's sponsoring them. In terms of the timing, similar to the other ones we've talked about, there's two petitions at this stage. The first is the I-140. The second is the I-485 or green card. You can also file this through consular processing. The normal process for perm is that you're working for a company in the United States, and then they sponsor you, and you will file the I-485. That being said, the perm is for a prospective future position. So hypothetically, let's say your company started to sponsor you for a perm and you had to move abroad again for a reason, for some reason, some family emergency, but you still wanted the green card ultimately, they could continue that process for you. It's not required that you remain in the United States while it's happening. And then they would just file for you through consular processing as opposed to through the I-485. One thing that comes up a lot in this case, unfortunately, often for kind of Indian and Chinese nationals, is that they get to the I-140 stage, they get an approval, but then the category is not current. The categories are quite backlogged for the EB2 and EB3 for Indian and Chinese nationals. So if your category is not current at that time, then you need to, perhaps you have an underlying visa, perhaps you have an E-2, so you can kind of continue with that and renew that while you wait for your category to become current. If you're on a visa like an H-1B, then there are specific, kind of things built into the law that allow you to have some extensions while you wait for your category to become current. It's also important to notice that for this, you can sponsor your family members as you can for, the EB1A and the EB2 NIW. Your family members can be dependents on your application. They can file their own I-485s or consular process, and that is allowed for spouses and any children, unmarried children under 21. All right, so let's talk about E-2 to EB5 investment. Some clients on an E-2 investor visa may opt to move to EB5, and in many cases, they can use their existing business. The EB5 Regional Center program was stalled last June, but the direct investment program has not ever required reauthorization, so it was always available and it continues to be available. When Congress reauthorized the Regional Center Program on March 11th, they increased the investment amounts from 500,000 and 1 million to 800,000 and 1,050,000. The investment can be made in a business that is an existing business that was started after 1990. So long as the business was started after that, EB-5 can be an option. You can use some or all of the investment that was made in the initial E-2, but not all amounts are going to count. So for example, EB-5 does not permit the inclusion of legal or administrative fees to be included in the investment amount. So for new regulations and targeted employment areas, the investment amount of 800,000 or higher depends on where the business is located. So if it's located in the TEA, a targeted employment area, meaning an area where the unemployment rate is at least 1.5 times the national average, then that lower amount of 800,000 will apply. The new rules do make it harder to qualify for a TEA. So in many cases, the higher amount may apply. Which investment may be included? So most investment can be included, but not all. You do have to sit down with an immigration lawyer to see exactly what can be included. The investment must also be committed and at risk, and idle cash in a bank account will not work for the EB-5. So we can also talk about investments made over time. Investments can be made over time, which has been helpful for many of our E-2 clients. We have one EB-5 direct case where the person invested the required amount over a 10-year period. So this is possible to move from the E-2 to EB-5 over a period of time. The investment funds do have to come from your personal resources and not revenue from the company. So it is important, again, to speak with the immigration attorney to understand kind of what is going to count as investment. If you just leave money in the company, that's not going to count. So talking about the differences between the E-2 and the EB-5, the programs have some similarities, but there are many differences. So for example, an E-2 permits purchasing a company and an EB-5 does not. For an EB-5, you have to invest in the business and the investment must lead to job creation. When you buy a business, the money is going to go to the seller. This doesn't qualify for EB-5. Also, the source of funds requirement is more complex for EB-5. Finally, EB-5 does not require a particular ownership percentage as the E-2 does, and nationality does not matter the way it does for an E-2. EB-5 does require some ownership of equity, but it can be a very small amount as opposed to the 50% that is required for the E-2. So let's talk about the 10 full-time jobs. The business must create 10 full-time jobs. The jobs must be full-time and for US citizen or green card holders only. You need to provide a detailed business plan, which is credible and shows how you will create the 10 full-time jobs. And the investment must be linked to the job creation. So for example, if you invest in a company, but the employees are already at the company, those employees don't count towards the job creation requirement for you. For an EB-5 filing, the petitions that you need to file are the I-526, and that's the first step where you show kind of your source of funds and your investment. The second would be the I-485 or consular processing to get your conditional green card. And then the last step is the I-829. And this is where you have to show that you've hired the 10 full-time workers. And only after that has been approved will you get a permanent green card that can last for 10 years. Prior to that, once the I-526 is approved, when you file for your green card, you can only get a 2-year conditional green card. One big change that's recently happened for the EB-5 program is that an I-485 can be filed concurrently if the applicant is in the US. So this is a great benefit for many investors, especially given that I-526s can take an extremely long time to be approved. So there are also some other green card options that we won't go over in as much detail today, but I think are good to mention. So one is the diversity lottery. So this is something that you can apply for each year. There are certain countries that that are eligible, so you want to take a look and see if you're eligible for that, and you can enter that without kind of jeopardizing your E-2 status. If you're not selected, it's fine. It doesn't kind of damage your ability to renew your E-2 in the future. There are also humanitarian-based green cards for kind of various various people in various circumstances. There are special circumstance green cards, for example, helping the police with a crime. And then also, it's always possible there is some type of immigration reform. Over the years, there have been many bills that have been proposed to expand, kind of green card options, particularly for entrepreneurs. None of those have yet come to pass, but it's always something to keep an eye on because, there's always those possibilities. So I think other things to think about when you are considering the transition, from an E-2 to a green card or any other visa to a green card. So, one is timing. For EB-5, as we talked about previously, there are very long delays for the I-526, but now there's this new benefit of being able to concurrently file the I-485 if you're already in the United States in a valid status that allows adjustment of status. Also important to consider kind of country-specific quotas. So that's where you would look at the visa bulletin to see if your category is current. If it is, then you are, able to file your green card application. If it's not, then you would need to wait until your category is current based on your priority date. You also want to consider kind of, travel and your visa expiration. So for some people, traveling internationally is an important part of their business, or they have family needs and they're going to need to be constantly traveling. That's something to consider if you're moving to a green card, because when you file your I-485, unless you're on an H-1B or an L, you cannot travel until you get work authorization, until you get work and travel authorization from USCIS. Sometimes those can take, anywhere from 3 months to 8 months or even longer. So if you can't, if it's not going to be okay for you to file that green card petition and stay in the United States for several months, you may want to consider consular processing, because that will allow you to travel freely on your current, non-immigrant visa. You also want to consider your visa expiration date. So certain visas, it becomes more difficult, to renew them once you have a green card petition pending, or even an immigrant petition that's been filed or approved. So, for example, the TN visa is one where very, very difficult, really not possible to get TN renewed after you have, kind of filed an immigrant petition or a green card petition. So that's something to keep in mind as well. If your visa is going to be expiring soon, you may want to renew your visa before you file your green card petition, to give you with underlying status for as long as possible. Other things to consider are dual intent. So which visa are you on? Some visas like the E and the O are kind of these quasi dual intent visas where there's a very low standard to prove your non-immigrant intent. Some visas like the H and the L are completely dual intent friendly. You can file a green card petition and travel freely on the H and the L without any worries. And there's other visas, the F visa, the TN visa, these other visas that have higher standards for non-immigrant intent, where you're really, not going to be able to renew those visas or, travel on those visas once you reach a certain stage of the green card process. Another thing to consider are parallel green card strategies. So there's nothing that stops you. For example, if you feel that, you want to go after the EB-1A, but perhaps you haven't reached the level in your career yet, where you think that it will be a strong case. Perhaps in the interim, you could apply for the EB-2 NIW. The EB-2 NIW right now doesn't have premium processing for the I-140, but the EB-1A extraordinary ability does. There are recent changes that indicate the EB-2 NIW will, get premium processing soon, hopefully within this fiscal year. But so it's possible to pursue these green card strategies in parallel with one another. Also, for example, if you have a long-term plan, you're interested in turning your E-2 into an EB-5 direct investment, as we mentioned, you can invest over many years. You could always have that running, in the background, making those investments, while you perhaps work on some of these other categories that might be available to you. One thing I think, planning is really key, especially if you have children and you're interested in your children getting the green cards. You really want to be working closely with an immigration attorney, because once your children turn 21, they're no longer eligible. There are, if you filed petitions in the past, and the petitions, there's a Child Status Protection Act that does allow for some flexibility, but it's very important to kind of start planning early, especially when your kids are young, to make sure that you have a strategy in place if you want to get green cards for your entire family. All right, so we've reached the end of the presentation. And we don't have any questions. So thank you so much for your time. I appreciate you taking the time to attend this webinar. And as I mentioned, this will be recorded and you will receive a copy of the PowerPoint, the webinar, and a link to sign up for additional webinars. Have a nice day.